So in 2026, the United States is going to hit its 250th anniversary. But instead of just gearing up for another round of historical celebrations and fireworks, there's this massive legislative proposal known as the POPULIST Act. And the whole idea here is to use this exact moment to completely rebalance the nation's justice system. Today, we're unstocking the details of Title I from this 2,000-page bill. The whole mindset behind this legislation actually draws straight from Thomas Paine's famous words back in 1776, "We have it in our power to begin the world over again." The vision is basically to use the 250th anniversary not just to look backward and commemorate the past, but as a really rare opportunity for sweeping national self-correction. To pull off that kind of transformation, Title I leans on a really ancient framework. It's the concept of a jubilee. If you're not familiar, historically, a jubilee is a cyclical time of release, repair, and return. Think of it like a season for forgiving debts and rebalancing a society that's maybe become a little too unequal or harsh. This legislation takes that exact jubilee principle and applies it to the American justice system, aiming to roll back unnecessary punishment and seriously rebuild civil rights. So how exactly does Title I propose we actually do that? Well, we're going to systematically unstack its 5 core pillars today. We'll cover privacy in the courts, sentencing and prison reform, de-escalating the drug war, police accountability reforms, and finally, what the bill calls justice for the 100%. Let's kick things off with Pillar 1, privacy and the courts. It's all about modernizing our protections. You know how under the traditional Fourth Amendment, law enforcement needs a physical judicial warrant to search your property, right? Well, in the digital age, there's a massive, glaring loophole. Right now, government agencies can just buy your location data and web browsing records straight from private data brokers. The Populist Act includes provisions to ban this practice. The underlying principle is pretty straightforward. The government shouldn't be allowed to just whip out a credit card to bypass the Constitution. And this modernization extends right into the physical courtroom, too. The legislation proposes what it calls opening the courthouse doors to ensure fairer access for everyone. I mean, have you ever just blindly clicked agree on an app's terms of service? You probably signed a forced arbitration clause without even knowing it, which basically prevents you from seeking justice publicly. This bill outright bans those. It also repeals the Prison Litigation Reform Act, making it way easier for incarcerated people to report unlawful conditions. Plus, it funds a legal services voucher program through a tax on lawyers, so courtrooms aren't just an exclusive club for the wealthy. Moving on to Pillar 2, sentencing and prisons. This is about creating that Jubilee pathway. The core goal here is getting back to individualized judicial judgment. To make that happen, the bill proposes completely repealing federal mandatory minimum penalties. It also restores federal parole and good time credit rules. The foundational belief here is that people actually can and do change, and the justice system needs to leave room for meaningful rehabilitation instead of just defaulting to permanent exclusion. For folks currently serving long or drug-related sentences, the bill outlines a very structured second-look process. Here's how it works. First, they provide appointed counsel to the incarcerated individual. Second, they hold a formal court hearing, making absolutely sure victims are notified. Third, the court takes a really thorough look at the individual's rehabilitation alongside public safety interests. And finally, if it makes sense, they can apply sentence modifications retroactively. It's basically a true Jubilee release in action. Beyond just the sentences, the bill goes aggressively after the financial extraction happening inside the system itself. To put an end to prison profiteering, it proposes entirely eliminating the federal use of private for-profit prisons. Gone. It also scraps medical copays, requires facilities to hand out free basic hygiene products, caps predatory commissary pricing, and completely prohibits the revenue-sharing kickbacks that cause those astronomical phone rates for families just trying to stay in touch. Now, pay attention to the number 15 here. The legislation restricts solitary confinement to a maximum of 15 consecutive days. The specific goal is to formally align domestic United States prison facilities with established United Nations standards regarding the basic, humane treatment of people in custody. All right, Pillar 3, the drug war. It's time to de-escalate policy. This is a massive structural shift. The legislation proposes completely replacing federal criminal punishment for personal drug possession with a simple civil penalty. And the cap? No more than $100. It also bans collateral consequences. That means you couldn't be detained or suddenly lose your federal benefits based solely on a personal possession violation. When we look at marijuana specifically, the bill outlines a really comprehensive shift. First off, it federally legalizes and taxes it. But crucially, it mandates automatic retroactive relief and expungement for past marijuana-related sentences. We're talking about clearing records so people can actually get jobs and secure housing. And lastly, it creates a safe harbor so banks can finally provide services to lawful marijuana businesses without the constant threat of federal money laundering charges hanging over their heads. The de-escalation keeps going by ending federal civil asset forfeiture. Simply put, the government can no longer seize your cash or your car without the standard protections of an actual criminal conviction. It ties the loss of property strictly to due process. The bill also repeals that severely outdated crack cocaine sentencing disparity, and it clarifies espionage offenses to protect national security whistleblowers who act without any intent to cause harm. Let's dive into Pillar 4, Police Reforms, focusing on accountability and community trust. By integrating provisions from the George Floyd Justice Act, the bill proposes some incredibly strict rules aimed at restricting anonymous power and heavily increasing accountability. It reforms qualified immunity, which gives victims of unlawful policing a realistic path to civil justice. It restricts no-knock warrants, completely bans chokeholds, mandates training on the absolute duty to intervene when witnessing misconduct, and requires visible identification during any public enforcement actions. The legislation also establishes what it calls the Peace Act framework. This breaks down a very strict sequence for federal police use of force. Step 1. Any force used absolutely must be proportional to the threat. Step 2. Officers are explicitly required to utilize reasonable alternatives and prioritize de-escalation whenever it's available. Step 3. Deadly force is strictly limited to true last resort situations that involve imminent serious bodily injury or death. To make sure these standards are actually enforced across the board, the bill establishes a National Police Misconduct Registry. This registry would collect complaints, discipline records, and civil lawsuits. The stated goal here is to stop that loophole where officers with serious misconduct histories can quietly resign during an investigation and just casually move to a different agency in another town with zero transparency. Finally, we reach Pillar 5, justice for the 100%. Let's look at the moral logic behind the entire bill. So, why are folks throwing their support behind Title I? Well, it rests on a few core arguments. First, there's a fundamental belief that the U.S. simply incarcerates way too many people for far too long, and that real public safety comes from healthy communities, not just more cages. Second, advocates want to ensure courts are truly open and civil rights are actually enforceable for everyone, not just massive corporations. Third, they view addiction and trauma primarily as public health issues, rather than just criminal ones. And finally, they argue that police power absolutely must be entirely transparent and bounded by law. When you distill it all down, it comes to a twist on a phrase we all know really well: liberty and justice for the 100%. The authors are making the case that a justice system should repair way more than it destroys, and that literally no American should be permanently excluded from society. So I'm going to leave you with a pretty provocative thought to chew on. America's 250th anniversary, is it just going to be marked by ceremonies and fireworks? Or will it be marked by a massive jubilee that fundamentally restructures the justice system from the ground up? The Populist Act certainly lays out a detailed 2,000-page blueprint for that second option.
Release, repair, and renewal. We can have a Jubilee in 2026. The United States can address its spiritual and economic debts by enacting the Populist Act. Learn more about this bright and bountiful future at votewithbrian.com.